Yeah, thank you very much. I now have the pleasure to give you an update on the EU medical device regulation, on the recent trends and developments before we then enter into a very exciting panel discussion for which I'm very much looking forward. But now to the EU medical device regulation. And I will very briefly give you an update or maybe give you the backgrounds of the date of application and what the current problems and public discussions are in Germany before I'm then hopefully able to give you some solutions about the problems that we are currently having. And then concluding with an update on the other key markets that we have in Europe. You all know that UK is not part of the European Union anymore since the Brexit that is effective since February 2020. And Switzerland, Mark, sorry, I don't want to stress your feelings here. And Switzerland, of course, is not part of the European Union, as you know, but not even part of the European Economic Area. So it's kind of called a third country in view of the EU MDR, like the UK is. So the EU medical device regulation, I think you're all very, very familiar with it if you are commercializing your devices in the European Union. Just very quickly, it has been published in the European Journal in May 2017, and there was initially planned to have a transitional period of 3 years. Then because of COVID, an additional moratorium of 1 year applied. So the date of application is May 2021. And you are all, or most of you are lawyers, you know the difference between a directive and a regulation. With a regulation, you're in the very comfortable position that it directly applies within the member states. So it is not necessary, as it was for the old medical device directive, that this has been implemented by an act of the national legislator, that it is applicable in each member state. So this regulation sets up a fully harmonized legal framework for the regulatory framework for medical devices. So whenever you place a product legally on the market, you manufacture it, you have to do clinical investigations, then you can look up to the MDR, and there you find the harmonized framework for the entire European Union. This is the good news or the good message. The bad news is that it hugely extended the regulatory obligations not only to the economic operators but also to the manufacturers when it comes to the technical documentation, design and intended purpose of medical devices. Just to give you an example for this, the MDD, so the old regime, the Medical Device Directive, applicable until May 2021, had only 17 articles and 10 annexes. And when you now look up the EU Medical Device Regulation, it has 127 articles and 17 annexes. So you can, alone from these numbers, understand what kind of challenge manufacturers and all the other economic operators like importers, distributors, authorized representatives, but also notified bodies currently are having to keep with the regulatory obligations up to speed. So what we have seen in the past for our clients and for the entire medtech industry, what are the major challenges in context to the MDR? This is certainly clinical evaluation. It increased a lot. So with the MDD, there was still a focus on purely safety of a medical device. Under the MDR, there is not only safety, it's also performance data that you have to obtain when you do clinical investigation for your medical device. And this means you have to show clinical benefit. And clinical benefit, the legal definition of it is that there is a positive impact on the patient health. So it's a shift from a focus on the safety of a medical device to also obtaining performance data. So this is one of the greatest challenges that medical device manufacturers are currently having when they want to obtain an EU declaration of conformity according to the MDR. What is also quite challenging, we have new economic operators identified, not only identified but addressed in the EU medical device regulation, and they have imposed a lot of new regulatory obligations. we now have not only the manufacturer and the authorized representative, it's also the importer and the distributor who have to fulfill certain duties. And when you have a look at Article 13 for the importer and Article 14 for the distributor, is such a page of regulatory obligations that they have to fulfill. And for you, if you are a manufacturer, then you also have to consider that it's best and common practice in Europe, in the European Union, to include these regulatory obligations of importers and distributors in the respective agreements that you might have with them. So we have seen a lot of homework that was done by manufacturers by just concluding quality agreements or attachments to existing distribution or importer agreements. Then a challenge, certainly just for the sake of completeness, or I don't have completeness here when I report about 127 articles, but what was only a great discussion in the public, the upgrade for software as a medical device. Most of the softwares under the MDD were Class 1, and Class 1 means that a conformity assessment procedure does not require the involvement of a notified body. Most of them, I think some data say 80%, now receive an upgrade to 2A or 2B, risk class 2A or risk class 2B. And this needs the manufacturer for the software as a medical device to execute service agreement with notified bodies. And we have a real shortage of notified bodies currently. And the reason for that is that we have a switch from the MDD to the MDR, and there were a few transitional periods applying, but not for notified bodies. So the EU legislator has said that when the MDR enters into force, the accreditation of a notified body will become immediately void. So you're all aware of the change of the regime in the US in contrast to the European Union. We don't have an FDA, we don't have a competent authority who is issuing a marketing authorization for a medical device. We have notified bodies. A notified body is a legal person, and the TÜV Süd, TÜV Rheinland and DEKRA, they are GmbHs, and that they are empowered to do this conformity assessment procedure and then issue an EU declaration of conformity. They need to run through an accreditation procedure that they can call themselves notified body. So this has been done in view of the MDD. With date of application MDR, all the accreditations of notified bodies become void. That means that they have to start from nil, from scratch. They now have to get an accreditation under the MDR. And you can see that there is a huge bottleneck of notified bodies currently applying in the European Union. We were still in very comfortable times in 2012, 2013, where we had around 80 notified bodies. And during time, it's slowed down to 59. That was because a lot of little players just stopped business. We had some mergers of some players. So we had a constant number of 59 notified bodies from 2016 on. And then I told you the initial date of application of MDR was May 2020. So all the notifications became void. And in parallel, the notified bodies tried to get an accreditation under the MDR. And this is extremely burdensome, very much time consuming. And this now leads to the fact that I think BSI Amsterdam was the first notified body to get this accreditation in January 2019. Then TÜV Süd came, DEKRA came, some Spanish notified bodies. And now we are in a situation, 2022, 1 year after the date of application of the MDR, that we only have 34 notified bodies and much more workload. So this is a table that was drafted by the German BVMed, and now I'd show you by a slide of MedTech Europe that you can see that not only the number of notified bodies goes down, but also the workload goes extremely up. So I'm just telling you that a conformity assessment procedure under the MDD required to see if a medical device is in compliance with 17 articles, and now it's very easily set with 127 articles. So the capacity and the workload, there is a huge gap between both of these scales. So this leads to a fact where the public discussions in Germany and all among the European Union, we are now fearing a lack or a bottleneck of supply bottleneck, because we also have a transitional period for CE marks. You can see that we are here in a rather comfortable position because we can say that from date of application, May 2021, the CE marks we call it legacy devices. And legacy devices, this is a term that describes that it's a medical device that is still with an MDD CE mark, so that legacy devices can still be marketed. So the CE mark does not become void after the date of application of the MDR. You can still use it until your CE mark is effective. But there is one total deadline, and the MDR says after May 2024, you are not allowed to use your MDD certificate anymore. Some numbers, statistics say that still 23,000 legacy devices need an MDR certificate. And when you have a look, that only 8,120 manufacturers have submitted an application for an MDR certificate, that there are still something like 15,000 without even a submission. And then you have a look at the timeline, and the statistics are currently saying that 82% of the MDR certificates, including the quality management systems, require 13 to 18 months. And when you have in mind and you take into consideration that we already have November 2022, and the total deadline for the MDD certificates is May 2024, then we are already around 16 to 17 months. So this is why the current public discussion is very much about the expected lack of supply that we will have from May 2024 on. So what we are always saying, and the public discussion is always saying, the message is always get MDR ready when you are a manufacturer and you still market your device under the MDD. So this were the bad news. Now I try to show you what kind of maybe short-term solutions you can try to take into consideration. This is, for instance, you need a CE mark only to legally place your medical device on the market. Once this is done, it can still be made available. So the European legislator is saying, once it's on the market, it's legally placed on the market with an MDD CE mark, you can still make it available for another year. So what you can do shortly before your MDD certificate will expire, you can maybe sell it to your distributor. You can hand it over maybe to your customers. And what you can also do to benefit from this so-called warehousing deadline or sell-off period that applies until May 2025, according to the Commission Blue Guide. I have to mention that the Commission Blue Guide is a document from the Commission that gives guidance on the interpretation of the European product rules. And this has been renewed in June 2022. And you can firstly find that placing on the market can already been agreed or can already have taken place when you are in serious contract negotiations with one of your customers. So it's not only that you need an oral or written agreement, physical handover is not required. It's already when you start contract negotiations that you can consider your product being placed on the EU market. And this means when you want to buy another year, or if you want to maintain the marketability of your device, then you either sell it to one of your distributors. They can have it on stock and still make it available to the end customer until May 2025, or you even enter into contract negotiations. Another soft way, I call it, to place something on the market is that you hand it over to your third-party logistic provider, or in the terms of the Commission Blue Guide, you hand it over to the fulfillment service provider. And when they have released it for free circulation on the union market, according to the Blue Guide, this is already being considered as placed on the union market. So this is something where you can, when you the expiry of your MDD certificate is very close, you can maintain the marketability of your legacy devices. A second solution for running out of, if you're running out of your CE mark, is that you can apply for a marketing authorization as the national competent authority. I've just said that we don't have an FDA. We are working with notified bodies in the European Union. They are doing conformity assessment procedure, then issuing EU declaration of conformity, and based on this you can CE mark your device, and it's marketable in the entire European Union. If you are not able to run through, let's say, a successful recertification, or you're not able to get an MDR certificate on short note, what you can do when there is a public interest that your medical device is available on the market, you can go to the National Competent Authority. In Germany, it's the BfArM, the Federal Institute for Drug and Medical Devices, and you can apply for an authorization. It's an administrative act, and they would allow you, the German competent authority, the BfArM, would allow you to place your medical device on the market for a certain period of time. You have to show that it lies within the public interest, and it's also crucial to maintain the patient health and safety. This is something that already exists for a few years. It has never been used until 2016, 17, and I think also 18. And currently, it's not common practice, of course, but it's a typical means for manufacturers who were not able to recertify their medical devices or not yet having obtained an MDR certificate. Then we see strong political initiatives from the member states and the leading industry association. In this case, it's SNITEM, the French Industry Association, and the BVMed. This is the German Industry Association. And they have a call to the European Commission. They are writing letters to the European Commission. They're approaching it, and they are saying we need to extend the transitional period for legacy devices. For the high-class medical devices, class 3, and also implantable medical devices of 2 years. So that would bring the deadline from May 2024 to May 2026. And for all the other devices, class 1, 2A, and 2B, for additional 4 years. That would then maintain the marketability until 2028. Another claim from this political initiative is that the notification procedure for notified bodies should be shortened, and the warehousing deadline. So for legacy devices who are already placed on the market, they can still be made available until May 2025. This deadline should be abolished. And in my view, it is not unlikely that this political initiative will be successful, because an indication for that is that it's made, or this political initiative made it on the agenda of the EBSCO. EBSCO it's not an association, it's all the member states and the health ministers come together in this committee. It's a council, and they then give a recommendation to the European legislator what should be changed or not. So I believe there's at least a certain likability that this political initiative will become successful in the near future. So this very briefly on the MDR, EU MDR update. I'm now coming to an update on 2 further key markets that we have in Europe, that is the United Kingdom and also Switzerland. It's indeed an update when I made this slide. So, or let me go one step back. You all know UK is not part of the European Union anymore. This is the consequence that the MDR is not applicable anymore. So that also means that the CE marks, so under MDD and MDR, should not be accepted anymore from a very formal perspective. But certainly there is a very overriding public interest that CE marked medical devices are still available in the UK. So the UK legislator and the MHRA found a solution where they have said we will still, for a transitional period, accept CE marks, MDD or MDR, until June 2023. I just learned from a very dear client yesterday that this deadline has been extended to June 2024. So if you are in the possession of a valid CE mark, MDD or MDR, you can still place your product on the UK market until June 2024. The only additional burden that you will have, if you not have already fulfilled it, you need a UK authorized representative, or they call it a UK authorized person. And you also need to notify or register your devices when you place them on the UK market with the MHRA. Same requirements for the Swiss market. The Swiss, they have never been part of the European Union or the European Economic Area. What has happened with Switzerland? The Commission had a mutual recognition agreement with Switzerland, and they were not able, because of a political dispute between Switzerland and the Commission, to renew it at the date of application of the MDR. So there is no mutual recognition agreement anymore in place. So what did the Swiss legislator? They have amended their Swiss medical device regulation and are referring now to the medical device regulation. And in effect, the MDR is still applicable in Switzerland. And also CE marks are recognized, accepted to place your device on the Swiss market. What they have also introduced is the necessity, the requirement that you are appointing a Swiss authorized representative, and that you register your device with Swissmed before you place it on the market. So this is a very brief update on the new regulatory requirements and discussions that we have around the EU medical device regulation and also around UK and Switzerland. And I'm happy to hear if you have any questions. If not online, then I'm happy to, please.
Get more color as to what's... Can you provide more color as to what's the acceptable sort of data standard or clinical experience to get a device on the market?
Yeah, that's a very good question, and there is no guidance and no case law yet. So you are referring to the point that when you, if you want to obtain an MDR certificate, you also have to show performance data now. And this is something that is complete black box for us so far. We don't know it. I don't have any intelligence from our clients who already have an MDR certificate. So I can't really say what you need to submit that they accept the clinical benefit, so a positive impact on patient health. I don't know if one in the room would like to share this information with us if they already have an MDR certificate. But this is really something I would expect also that it would be handled differently depending on with which notified body you are working with. So yeah, that's something we still need to see, and the developments will be very interesting.
I could maybe speak to the here.
Please.
Oh no, I was just going to provide it. It's chat. It's fine. It's to address the comment.
We have time.
Thank you.
Actually, Mahtab, if you want to, we have a little
Oh
extra
yeah, no,
time.
but he was chatting, so I was addressing his comment.
Please,
Go ahead.
Marta,
Yeah,
go
that's
ahead.
fine. So we don't have an MDR
I'm curious.
certificate yet. We're in the middle of a very, what I would consider very simple software device, which was a 510K cleared product in the US, went through very easily. And we worked through BSI. They're getting very hung up on what is the clinical benefit of your software device. It measures volumes, it measures lung, it's focused on the lung. And I feel like they're really struggling positioning that clinical benefit, which I think in the past they would have looked at a clinical evaluation, given it a thumbs up, and it would have been done. But that's really where they're getting hung up. And I think they're looking also for more statistical rationales around your clinical data, whereas in the past you could have said, oh, we did a 20-patient study, the safety looks good, and performance was fine, you know, and they're really looking for more statistical rationales as well.
Thank you. So thank you very much. I'm now happy to hand over to the panel discussion, which will be led by Amanda. Thank you.